This came out into the news. Mitt Romney, I saw this thing. First of all, I should take a look here. Mitt Romney's sister-in-law, Carrie Elizabeth, found dead at 64 on LA Suburb Street. The sister-in-law of former presidential nominee and Utah Senator Mitt Romney was found dead on a street in Los Angeles suburb Friday evening, according to officials and reports. Carrie Elizabeth Romney was discovered dead near a shopping mall parking garage in Venice, California. She was 64. Her death is being investigated, and the cause and manner have not yet been determined, according to the reports. County Recorder's Office. Former GOP. Okay, we don't care about that. It is unknown at the moment if she jumped or fell from the multi-story parking garage or nearby building. Yikes. The medical examiner's office and Mitt Romney did not immediately request. Okay, so there it is. There's the parking garage. I guess that's where she hurled herself off. So I saw that first, and then I saw this thing here. Yeah, like the video, nerds. Like, subscribe, all that stuff. By the way, I did it right this time. I put a note on Substack. I said, this is going out, and I put it out a few hours before. So if you've gone over to Substack, tyleryonke.substack.com, you can go over there and you will get notifications, at least to your email, to your phone, whatever, on your Substack you have there. You'll be able to see every time I'm going to be going, at least approximate time, okay? Okay, so this is the news report. Mitt Romney's brother tried to make sure estranged wife got nothing in divorce before her tragic end, docs. And here's Mitt tried to make sure his estranged wife got nothing in the divorce. That's their Twitter. So then let's read it here. Matter of fact, okay, Mitt Romney's brother filed for divorce just 4 months before his estranged wife plunged to her death in a California parking garage and tried to make sure courts awarded her nothing in the split, court documents show. George Scott Romney, 81, filed the case against 64-year-old, okay, that's a disturbing age difference, Carrie Elizabeth Romney in June, citing irreconcilable differences. Okay, this is, by the way, this is in California, so I'm very aware of how all this is going to work. In papers obtained by the Post, Romney, a seasoned litigator who previously ran for public office, sought to, quote, terminate the court's ability to award support to either person in the divorce court documents show, suggesting he wanted to make sure the courts didn't step in and give his wife any assets. Holy shit, I can't believe that they wrote that. Other documents from the split filed by Romney's lawyer noted that both parties had agreed to mediate property and support. Carrie, however, returned fire in her own filings, requesting that Romney provide her with alimony and pay legal costs of the divorce. She also requested her name be restored to her last name. This case was ongoing when her body was found. Okay, first things first. Let's talk about the death. Well, first of all, I want to say this. When you file for dissolution in California, it's a 3-page form, the petition, okay? And you check the boxes. One of those things, I mean, I could just, maybe I'll do that. Maybe I'll just do that here so you guys have an idea of what we're actually, oh, that's the wrong form. Sorry, I went to the judgment form. Let's see if we've got this. There we go. Let's go here. Okay, so we got a petition form. Very simple and easy. You fill this stuff in. You say, hey, I'm going to be a dissolution of marriage. You could also do legal separation or nullity. It never gets processed. We are married, okay? Residence requirements. We've been in the county for 3 months, the state for 6 months. Boom, boom, boom. Statistical info. Date of marriage, date of separation. How long does that mean that you were married for, and how many months, years and months? If it's a domestic partner, you fill that in. If you got kids, we'll worry about that. Legal grounds, well, you'd say divorce and irreconcilable differences. Okay, pretty simple there. Kids, wait, and by the way, this is just a petition for what you want. Okay. Child support, okay, spousal support. So likely this guy said, let's terminate it for both parties. Okay, we want this. Now, property, I imagine he did what most of us do, is he said, we're going to confirm this. And then he does like this attachment 9B, and it's basically like you do a definition. Hey, I haven't, discovery is still ongoing, and disclosures, we'll do those at a later date. But community property or separate property is everything before marriage, after said date of separation, or conveyed by or received by gift, divine, inheritance, blah, blah, blah. Okay. Then you go down here to community property. It's a very similar thing. Other things. Hey, I want them to pay their own attorney's fees, blah, blah, blah. Now, this petition means absolutely zero when the other person responds, because it means something, right? It's get some statistical stuff, and you could do amending if there's different things to do. However, the main point of this is you get a case. The court, unless you are super, super specific and attach a bunch of different documents to this, of saying who gets what, because the idea is if they don't respond, then you can get a default judgment, like what happened with Alex Jones, except you're getting it based on the fact that they didn't respond in 30 days. But once they respond, now you have to go to court for all these things, okay? So now you have to go to court. And so when it said, oh, she responded by saying, you're going to pay me out. Yeah, because she did a response, and she's like, no, I want spousal support. And just because he said he wanted the court to terminate it, it means absolutely zero. Okay, I'm just saying it means absolutely zero. Now, here's the other more disturbing part, which is if you go up to the document in the post here, what they said, it said he sought to terminate the court's ability to award support. That's just spousal support. But then it says, suggesting he wanted to make sure the court didn't step in and give his wife any assets. That is just blatantly wrong. That is not even close to being the case. They are going to have to, unless they had once again, stuff that you acquired during the marriage, you're going to split it. If you had separate property, it's going to be still separate property. You're not going to split that unless you've commingled it. Okay. And we'll get into all that. My point, and then lastly is, does any of this matter for her estate? She died before they got divorced. Okay. They were going through a divorce. I've had a few deaths from clients, opposing parties, before the judgment is entered. One we had signed, ready to make an agreement, hadn't entered it, and then my client got killed by her boyfriend. She was bad way. Then another one, opposing party, we were coming to an agreement, but we were actually going to be going to trial just on a few issues. She dies of cancer. I had another one that got killed in a car wreck, opposing party. So what do you do on those? Essentially, you file what's called an abatement. It just drops the case. They didn't resolve it. I've had another one where we are still going to trial. He died right before Christmas or right after Christmas, but they knew it, and he wanted to make sure she didn't get his stuff. So they filed what's called a bifurcation, which is status only. So the status of his marriage and her marriage was that they were divorced. But we reserved all issues for division still. So he dies, and then he's trying to screw her now with his estate, or his mom is. So that was the one that they at least solved. I don't believe this sounds like to me, this was very much in the pendency, the early stages of the divorce. So that was not the case. So my point on this one is, he got it all anyway. He got it all. He didn't have to pay support. Okay, fine. Did he push her? I mean, it does make sense, right? I don't know if he did or if someone else did, but something happened to her. So, that would be interesting. There was this other article here. I don't know if they did the right thing here, citing irreconcilable differences. He had a place there, who sought spousal support but seemingly battled financial struggles. She filed bankruptcy in December 20 under her former name. Okay. Here's his record of marriage. They had 5 children. Oh, so he was first married at 67 to 92. And then 2011 to 2016 to this other person. No children. And then this most recent one, pending filed, not finalized, the time of her death. So when did they file? They filed it in June 10, 2025. There's first of all, to even get a divorce in California, by statute, you have to at least have been 6 months from the date that you served the other party. He's going to get an abatement on this, and it's going to be dropped. And he's, this was interesting though. So I don't know if this had anything to do. It's not going to matter now. Scott transferred his $38,000 Valencia condominium to the George Scott Romney Trust in July 2024, pre-filing, potentially shielding it from division. Kerry had a prior bankruptcy. He's not shielding it from division. He's not. The only thing is, there's a good chance that he was his separate property, at which point he could transfer it, right? So it's not, I don't know. They're trying to make some things devious, some not.